Welcome, folks. Glad to have you with us. Glad to be with you. If you just joined us, you have missed coming up on 2.5 hours of everything you ever wanted to know about the Constitution but didn't know who to ask. I do. It is Roger Pilon. He is with us from the Cato Institute. He's the founder and director of the Cato Center for Constitutional Studies. And the ground that we've covered includes the Declaration of Independence, the Federalist Papers, the Anti-Federalist Papers, what the Founding Fathers envisioned, and the Constitution as they altered it through the years. We are now coming up on the 1940s, the Roosevelt years. We're going to cover the 50s, 60s, and 70s as well with Roger Pilon. And Roger, in the 1940s, when they passed, for instance, when the Wickard-Filburn thing, that essentially gave them the power to regulate everything, didn't it? I mean, is that why they can tell you who to hire and who to fire and under what circumstances? And
Oh, absolutely. The New Deal Constitutional Revolution in 1937, 38, and then completing it with the non-delegation doctrine disappearing in 43, essentially turned the Constitution on its head. The original Constitution, and through our first 150 years, was understood to be a document to authorize, institute, empower, and limit the government that was created through it. After the progressives during the New Deal got through, it was a document that authorized the government to do almost anything. The only restraints, the restraints that were meant by the framers to be the main ones, namely the limits on power, had gone as a result of the evisceration of the doctrine of enumerated powers. What remained was the Bill of Rights, and there we started seeing the court treat rights episodically. And that's the part I want to turn to now. You've got, as I said, a massive amount of legislation pouring through after 1938, federal, state, and local, and the court essentially stepping aside and letting it happen to a huge degree. By the time you get into the mid-50s, however, you start seeing the liberals, who were the children of the progressives, who are now in control of the government and sitting on the Supreme Court, having some reservations, especially with respect to the civil rights movement, which was now coming along. They realized that there was a serious inconsistency between Jim Crow and the principles that the country stood for. And so you had them trying to figure out a doctrine that would enable them to address this while not rolling back all the, quote, advances of the New Deal. The big case during the 50s, the biggest case, of course, was Brown v. Board of Education in 1954, which finally ended the separate but equal doctrine that came from Plessy v. Ferguson in 1896, and put a stake through the Jim Crow aspects of school desegregation. But it would not be until the Civil Rights Act of 64 that you finally had an end to Jim Crow. Nevertheless, the court started fashioning a doctrine, and it did it in the following way. As I said, it treated rights episodically. There were some rights that were thought to be basic and important, and other rights not. The basic rights now included not just voting and speech, but religion, and also the certain personal rights. The non-fundamental rights were, again, all the economic liberties that had been reduced to a kind of second-class status after the Jones and Laughlin decision of 1937, and those would be given short shrift by the court. Well, with the advent of the courts becoming more active now, rather than restrained after the New Deal revolution, with the courts becoming more active, you got a backlash among conservatives in the 50s and 60s. Some of it was without question rooted in racism, but others of it was rooted in a conception of states' rights in a non-racist sense. That is to say, the older understanding of the role of the states, and as opposed to the newer understanding of federal dominance over the states. these people, these conservatives, people like Robert Bork, the late Robert Bork, and to a substantial extent today, Antonin Scalia and others, called for judicial restraint. So you had two schools. You had the liberals, and both of them were essentially wrong. You had the conservatives who, in calling for judicial restraint, did not go back to the fundamental problem of the demise of the doctrine of enumerated powers. They made their peace with that. And so both they and the liberals were not interested in reviving the idea that Congress has only limited powers. The differences between the two were not on the powers side, they were on the rights side, whereas the conservatives called for protecting rights only that were explicitly in the Constitution, thereby ignoring the Ninth Amendment, which we spoke about earlier, which provides that we have both enumerated and unenumerated rights, and ignoring parts of the 14th Amendment that allow for rights against our states because they were for state dominance. In other words, the conservatives were largely small d Democrats. They didn't want the court engaging in activism. They didn't want the court implying its own set of values, as the court was sometimes doing. They wanted this to be decided all by the state legislatures. The liberals, by contrast, were reading rights episodically, finding rights nowhere that to be found in our Constitution, while ignoring other rights that were plainly there, like property and contract. And so you had both schools, both of them essentially wrong.
So one side is creating them out of thin air and whole cloth, and the other side is like a cafeteria constitutionalist. Roger Pilon is our guest. We are talking about the Constitution today, of all days, and we will continue this right after Fox News on the Zimmer Radio Network. If you want to find out more about Roger Pilon, you go to the Cato Institute website. That is CATO, Cato.org. Cato.org. When we come back, we'll get more details on things that have changed in the 50s, the 60s, and the 70s, and the Constitution. The Gary Nolan Show, the Zimmer Radio Network.